Give it will appear as to be mentioned. You're for the insurance company. Is there any section 5 application? So have you sub copy of that section 5 application? So without that, the matter cannot be taken up. You cause service in the meantime. It will come up in the next week. Whatever it is, without service, I cannot take up that matter. Okay, today is Wednesday. You serve it, it will appear on Monday. Yes. Minor was there. Mother has signed the book. Okay, let it appear as to be mentioned. Okay, let it appear. Let us. Anyway, it will appear in tomorrow or day after tomorrow. Okay, day after tomorrow, right?
But item number 1, Millard, is a second appeal. Millard, there are two applications which are pending.
Yes.
This was, Millard,
Appeal
admitted.
is admitted.
Yes, as appeal admitted.
Application for?
Application, Millard, the CAN 1. Since Millard wanted to know, Millard, when it was admitted long back in November 2006. Now, Millard, the CAN 1, Millard, is an application at the behest of the respondent.
On the
Millard,
for dismissal on the ground of abatement.
on the ground of abatement. And CAN 2, Millard, is an application. It's, Millard, a conjoint application, Millard, for setting aside of the abatement, condonation of delay, and Millard, for bringing on record the
This is
legal
your application can.
That is our application CAN. Now, Millard, Millard, the sole appellant, Millard, had passed away in 2021. And Millard, in between 2021 and the next occasion when the matter was listed before the circuit bench, Millard, this matter never appeared in the list. The records were lying in the principal bench. Millard, I am covered by a judgment of the Honorable Supreme Court. Millard, the Supreme Court has said that after admission, normally the appeals are listed after a prolonged period of time. So the learned advocate has no duty to keep on inquiring regularly as to whether the applicant or respondent is alive or not. On that ground, Millard, a delay was condoned and abatement was set as
1,424 days delay.
yes. Hey.
Okay, it is the date of the appellant.
Death of the appellant. Death of the appellant. Sole appellant.
Date of the appellant. So it was within the knowledge of the heirs.
Millard, the sole appellant, Millard, he was an aged person.
Yes.
And
So,
Millard,
so
he is-
had it been a respondent, the question of knowledge comes.
Yes.
But so far the question of appellant.
Yes. Before this, Millard, before this date, when the matter appeared before your lordship's list, in between, Millard, the matter never appeared. So we, Millard, as an advocate, we had no occasion to, Millard, contact the appellant or his family members or to inquire. And Millard, if I may finish, once I finish, you'll make your submission.
So in 2021,
Yes. And Millard, in between, Millard, all rustic villagers, Millard, it is a decree for specific performance of contract, which was, Millard, subsequently set aside by the first appellate court. So, Millard, kindly consider the background of the litigants and, Millard, the judgment of
let
the
me see which paragraph you have stated the grounds.
Millard, kindly, if Millard kindly takes the application. Millard would take, Millard, page, paragraph 5 onwards. paragraph 5 onwards, internal page 5 of my application.
Yes. Paragraph 5, paragraph 6. Yes. So you have stated the grounds. Yes, what you say? Your opposition? Yes. Which page? Have you annexed that or order?
Well, that probably your lordship's brief will not get last
25/7.
25, so probably that's
25/7. So the appeal, the paper books were filed in the
paper
meantime.
books have not been filed in the meantime. Miller, the records have been transmitted from the principal bench very recently. So lying in
Okay, it is a principal
principal
bench matter. So paper book is there.
acha, paper book হয়ে গেছে।
No, question is, it was before the principal bench.
Yes, Miller, the parties belong to the jurisdiction of the circuit bench, but earlier to 2019, since it was filed, the records were lying in the principal bench for a very long period of time.
Okay, when it was transmitted here, it is in the record.
Miller, very recently, Miller, after the last order, probably.
So
Miller,
it was admitted
admitted, Miller, earlier
in the
admitted
principal bench.
2006.
Okay, I'm going through this order 25/7/2025 or earlier order.
Well, my sole contention, Miller,
Let me other order. Wait, what is the other order? 19?
August 2025.
19th August 20.
Yes, after 90, Miller, probably.
Oh, this is 20 or 19 August. Yes.
19th August. So it was in August 2025, Miller, the matter was transmitted from the principal bench, not before that.
So when on 19 August 2025 was this application filed, the substitution?
No, it was not filed.
Okay.
Not filed. Therefore, Millard, since that is the fact, Millard, I would like to refer Millard to a judgment of 2025 passed by Honorable Justice Dipankar Datta. My Millard, it has been held that even if it is their application, once death come to the knowledge of the court may direct substitution immediately.
Yes. This is 2008 88 CC.
No, 2008 SCC is Millard, the point where I said Millard that the advocate do not have a duty Millard to regularly inquire, court should be lenient in considering setting aside of appointment. And since Millard, this is an appeal which has already been admitted. Millard, my respectful submission, although the delay is long, but Millard would
Yes,
also,
what is the other judgment?
Millard, the other judgment, Millard would take Millard, Justice Doctor's judgment.
You see, please give your learned friend one copy.
Yes. যেটা আগে দিলাম যে
Anyway, if they have adduced sufficient cause, it has to be condoned. If there is no sufficient cause, it has to be dismissed.
And Millard would significantly, Millard would note that after 2021, when the appellant, the sole appellant passed away, the matter was never listed. So there obviously there was a communication gap in between the council and the appellant or his legal heirs, which resulted Millard in this delay. Now Millard, whether this, Millard, whatever has happened, these circumstances, Millard would run over my substantive right. That is Millard, the only question your lordship would consider. This is an admitted appeal. It has been admitted on ground 4 and 5
Anyway,
of the
you have
memorandum.
filed your objection, let me consider them. And let me pass orders. Whatever is there, you have recorded, you have dealt that in your affidavit in opposition. Have you dealt with?
After 2021, it was
After
No,
20
No, never. Millard, whether it appeared or not, Millard, is a matter
One
of
order is
record.
25/7/2025. Oh, it's a very recent order.
Yes.
There are very few, let me see the record, whether there
The
are.
record will
orders.
speak for itself, whether it
Let me
appeared or
see
not.
what previous orders are there. Yes, 25/7/2025, one order is there. Oh, there was appearance, I think, once before the register administration. Yes. Yes, after this thing, 2021.
Millard would kindly, Millard, for my satisfaction, Millard, para 16 of the 2008 judgment. Millard, if Millard kindly just have a glance at it. Para 16.
Yes. Yes, record an order. Learned advocates for the parties are present. Heart learned advocates on Can 2 of 2025 and Can 1 of 2025. Hearing is concluded. Let the matter appear for orders on 22/12/2025.
Grateful. আমি দিয়ে দিচ্ছি।
No, you see, hearing is concluded. Only it is fixed for orders. Yes. Post title. Post title correction. Yes, learned
Name of the
advocate
petitioner is
for the petitioner is present. The matter is put up for necessary rectification in the cost title. It appears from order dated 15/12/2025 that the cost title, that in the cost title, the name of the petitioner is typed as Porosh Rai. It should be Taposh Rai, EAPASHROY. Let necessary rectification be made. Other contents of the order dated 15/12/2025 remain unaltered. 7. Yes, pass over. Yes, pass over. Yes, 9.
9.
Yes. Is it appearing for the first time?
first time.
Let us see. Yes. Is the order under challenge?
Order is order dated 24/11/2025.
So your prayer for setting aside that ex parte degree was rejected.
No, not rejected. The
Yes.
application for stay is rejected.
Oh, application for stay is rejected.
Rejected.
What is the suit for?
Suit for eviction. Actually, the application for order 9 rule 13 was filed, but the record was missing. That is also reflected in the order sheet itself. And the execution stage is kindly come the page number.
Yes.
Page number 32. That is the order sheet of the execution case. There, direction upon Nazir has been already passed for taking to execute the decree with the help of police
Yes, record an order.
at this stage.
Learned advocates for the petitioner is present, heard learned advocate for the petitioner. This, the petitioner, before this court, is a judgment debtor petitioner in missed execution case number,
Miss case number.
no. There is an
49.
execution case.
Order 9 Rule 13, that was.
The petitioner in his case, the number 49 of 2024, arising out of title suit number 132 of 2015, and is aggrieved by the order passed by the learned civil judge, second court, civil judge junior division, second court Jalpaiguri, in refusing the stay of the title execution case number 28 of 2024. Stop. The petitioner, being aggrieved by the said order, has come up with the instant application. Upon perusal of the order dated 24/11/2025, and upon hearing the learned advocates and considering the grounds, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite party in 1 week, and affidavit of service be filed forthwith. Let this matter appear before the next circuit. Pending hearing of this application, there shall be a stay of the title execution case 28 of 2024 pending before, arising out of title suit number 132 of 2015 pending before learned civil judge junior division second court Jalpaiguri for a period of 4 weeks from date. Yes.
Yeah.
Item 8. Yes. Yes, call item 8.
Lord, this is a division against the order passed by the civil judge senior division denying the amendment, allowing the amendment petition at the stage of trial, admitted trial. Lordship, the impinging order is the last part. Last part, Lordship.
Yes.
Order 6/17 has been filed on behalf of the plaintiff, and that has been refused to entertain and rejected that prayer. Now, Lordship,
You are the plaintiff before the
I
trial
am the
court.
plaintiff. This is the partition.
So at the time of evidence of the defendant, you took out an application
Yes,
for amendment.
yes. Okay, how, why, Lordship? Now, Lordship, come to the, first of all, the plaintiff. Lordship,
No,
plaintiff,
what are the grounds of your amendment?
on ground is they have been suppressed fact. At the time of WS, they have filed, they didn't disclose the actual fact. They transferred the property inter between them. And that has been come after the cross-examination from the mouth of the other. That has been the case, Lordship, and that has been admitted on the point of the learned court's order. That has been ordered, has been passed. If Lordship come to the order, page number 1.
And the suit was for?
Partition suit, Lordship. Partition suit, and in partition suit, there are 11 parties.
So
But-
you want to bring the subsequent events in the
In
amendment
the
petition?
amendment, Lordship. Why? Because Lordship, now Lordship, if the plaintiff come to the, if plaintiff I have filed in the first of page number 19,
Page 19.
page 19, Lordship. And there is a 12 defendants, but 11 is deleted because of she died. So now defendant is now 11.
Now, what amendment you sought? Let me see the your petition for amendment.
Lordship, so that has been my petition is just amended print. Page number P12 1274. $75 is the element. Lordship, this suit has been filed in the year 2015 and 2000, in the year 2017, they haven't filed their WS. And in WS, they did never disclose that the property has been
Okay, that was not mentioned by the defendant in their written
in
statement.
their statement, Lordship. That I have, WS also have annexed in the petition. And that has been disclosed from the mouth of the, when I.
Yes, record an order. Learned advocate for the petitioner is present, heard learned advocate for the petition. This application is directed against order dated 7/11/2025 passed by learned civil judge senior division Sodor Jalpaiguri entitled suit number 68 of 2017. Stop. The petitioner was a plaintiff in the said suit being aggrieved by the order of the learned trial judge in refusing his prayer for amendment has come up with the instant application. Stop. Heard learned advocate for the petitioner, peruse the petition file and materials of record. Upon hearing the learned advocates, it appears that the petitioner plaintiff filed an application for amendment when the suit was at the stage of trial and the evidence of defendants was continuing. Stop. The grounds furnished by the plaintiff was that it was not that the subsequent developments of the transfer of certain portion of suit lands were not within the portion of suit lands by the defendants was not within the knowledge of the plaintiffs. Stop. Although Order 6, Rule 17 proviso states that no application for amendment shall be allowed after the trial has commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. But considering the nature of the suit, where all parties are true sharers that have interest in the suit property, and considering the grounds furnished, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let the matter appear before the next circuit. Pending hearing of this application, there shall be stay of further proceedings in title suit number 68 of 2017, pending before learned civil judge senior division Sodor Court Jalpaiguri for a period of 4 weeks.
Development.
Item 7. Yes, who is appearing? You are appearing?
Yes, sir.
Yes. Call item 7.
For the petitioner lordship. Lordship, this application has been prepared for expeditious disposal of the title suit number 508 of 2022,
From when it is pending?
pending before the learned civil judge junior division, first for Jalpaiguri.
From when? Which
Uh,
year? Suit of which year?
2022, lordship. Lordship, I am.
What stage the suit
This
is now?
petitioner is a defendant in the original suit.
Yes.
Yes, the plaintiff, original plaintiff, who is the opposite party number 1, had made a prayer before the learned court for adding a pro forma defendant. And the learned court had admitted that petition and had ordered to submit an amended petition with
Has
added.
the
pro
trial
forma.
started?
Yes, your lordship, trial has started.
Trial has started.
No, your lordship, only the written statements and counter claims have been submitted by the defendants. But your lordship, this matter is that since 30th September 2024, since when the original plaintiffs had made a prayer before the learned court of adding a pro forma defendant, they haven't complied with the order of submitting an amended plaint with added party. And day after day, they are taking adjournments in the matter and they are prolonging the
So
trial.
is there, are you suffering from any interim order?
There was an injunction order, but it was vacated due to taking any steps.
Yes, record an order. Learned advocate for the petitioner is present. The petition is filed for a direction upon the learned Civil Judge Junior Division, First Court Jalpaiguri, for expeditious disposal of title suit number 508 of 2022. Stop. It is the contention of the petitioner defendant that pursuant to the direction for amendment, the said by the learned trial court, the said amendment was not carried out by the plaintiff, and on every dates adjournments are being sought for, and the defendants are suffering for the delay in disposal of the suit. Stop. In the facts and circumstances, this court is of the view that no fruitful purpose will be served by keeping this application pending. Thus, this application is disposed with the request upon the learned trial judge, upon the learned Civil Judge Junior Division First Court Jalpaiguri, to dispose of the title suit number 508 of 2022 expeditiously and preferably within a period of 9 months from the next date fixed.
Worship, can it be 6 months?
Let it be 9 months, you see, because it's a 2022 without granting unnecessary adjournment.
Bring for not today.
Not today.
I am for the petition.
So service is affected upon the opposite party.
Services affected, the.
Anybody has appeared?
Yes, yes. They have appeared, sick time also listed.
So let it be not today. Let us see tomorrow. Informing.
What is the point?
15. Okay, not today.
I have 16.
16. But can one is for? Yes. So shall I make it not today or make it in the next circuit? Yes, record an order. Learned advocate for the opposite party is present. None appears for the petitioner. Let this matter stand adjourned till 22/12/2025. The learned advocate for the opposite party is requested to intimate the learned advocate for the petitioner. Yes, not today.
19.
Not today. Acha, item 19, same as item 17. Same order. No, I'm making that same order. 17 also you are appearing. So same order as item 17. Or 16, same order as item 16. Not today. Not today. Not Passover.
55.
Yes, not today. Yes, not today. Not today.
Lordship, paying for Friday, Lordship.
28.
Yes, Lordship.
Okay, not today and tomorrow, Friday.
29,
Not today.
31,
Not today. Not today. 32 call করা দরকার নেই তাহলে।
33,
33, yes. You are for? Service affected upon the opposite parties.
Yes, Lordship.
The paper books are ready.
Yes, Lordship.
Who is appearing?
Lordship, I have served, Lordship.
33. So who appears for this Bajaj Alliance?
Lordship, usually appears, Hirok Burman is appearing for Bajaj, Lordship.
Yeah, just making it not today, you see. Acha, 33, nobody has appeared.
Yes.
Anyway, I'm requesting him to appear then. Let it appear tomorrow.
Lordship, then Friday, Lordship.
Acha, record and order. Learned advocate for the appellant is present. None appears for the respondent number 1, Bajaj Alliance General Insurance Company Limited. Stop. As Mr. Hirok Burman
Yes, Lordship.
appears for the said insurance company, he is requested to appear in this case. Learned advocate for the petitioner is requested to serve him copy of the paper.
Lordship.
Let this matter appear on
Friday.
19/12/2025.
five,
35.
35, I am
You are for the appellant.
I am for the appellant. Let the matter be fixed on Monday. There is, section 5.
Section 5 is to be filed. So, but it has to be served upon the opposite party also. Okay, not this week.
Monday. 36, same order.
36 also not this week. Is 7. Yes, who is for the appellant? Well, not today.
8,
Lordship.
Yes,
Lordship,
you
I am
are for the appellant.
Lordship, actually, I am appearing on behalf of the appellant Lordship. And
Scan 1 is whose application?
my application Lordship.
For connotation of delay.
Lordship. This is
Yes.
service Lordship.
Let me see. Yes, you are appearing for the respondent number 1.
Lordship, actually on the same judgment Lordship, two appeals have been preferred Lordship. One from the side of the petitioner and one from the side of the respondent Lordship. So the appeal being number 19/25, that appeal has been filed by the insurance company Lordship.
No.
So my
Today,
submission,
this appeal is before this court, okay?
Lordship, today is this appeal.
So you want both the appeals be,
Lordship, analogously heard and disposed of Lordship.
yes,
Kindly
record and order.
keep it tomorrow Lordship, he will be appearing tomorrow.
So that appeal, along with that appeal.
Then I'll do that.
Section 5 you have filed. Let this appeal appear along with FMAT,
19/25,
FMAT MV 19.
19
of 2025 on 18/12/2025.
Lordship. The service of all, let the
Yes, if he
service,
appears, well and good.
so should I,
Same,
take
same.
it back? Should I take it back? So I've already filed the affidavit of service.
Yes,
Lordship.
yes, yes. Take back the affidavit of service.
Grateful Lordship.
No, your learned friend will be appearing in the both the
Lordship,
same
both-
matter.
Lordship,
Anyway,
Lordship.
nine. Yes, you are for the appellant.
I am for that.
The insurance company advocate is not here.
No, it is not yet admitted.
No, question is there any delay?
Yes, my lord, there is a delay of 6 months.
Oh, then you file your section 5.
My lord, I will find.
Yes, record an order. Learned advocate for the appellant is granted liberty to take necessary steps. Let this matter appear before the next circuit. No, 40 you are appearing for the appellant. So file the, then section 5 application also. So defective, it is within time. Then why defective? So, but unless you file that application for stay, how stay will be granted? No, even before the next circuit also. Anyway, record an order. Learned advocate for the appellant is present and prays for time to take necessary steps. Let this matter stand adjourned till the next circuit.
Forty-two,
Yes, not today.
forty-three,
Yes, not today.
four,
44.
Yes,
Yes,
lordship, actually, in this matter, actually,
43.
I am the actually respondent here, lordship.
43.
I am the respondent. I don't.
Yes, you are appearing 43.
It is his appeal, lordship. It has been filed from the side of the insurance company. Yes, 44. I am appearing on behalf of the respondent, lordship, because I am the
No,
petitioner
no,
actually.
43 who is appearing? No, 43 not today, yes, 44.
44, lordship. Actually, in this matter, I am the petitioner, lordship, but here in this case, I am the respondent.
You are the respondent claimants.
I am appearing, lordship. Though
Yes.
the notice has not been
Respondent
served,
claimants. So the National Insurance Company has preferred this appeal.
lordship,
Okay. Now the question is, service can be dispensed with?
lordship. And the law,
And-
let there be direction to serve the copies, lordship.
Yes, record an order. Learned advocates for the appellant insurance company and learned advocate for the respondents number
One.
one.
Lordship.
Only one claimant.
Oh, no.
Others.
Others.
Respond number 1 and 2.
1 and 2. 1 and 2. One and
1,
others.
2 and 3 are present.
Take it.
As the learned advocate for the respondent number 1, 2 and 3 is present. Service of notice about respondent number 1, 2 and 3 is dispensed with. Learned advocate for the appellant prays for time to take necessary steps with regard to, yes, deposit of statutory amount.
Oh, delay actually, I think.
Delay is not there.
No. It's a.
No, but you see, for depositing the statutory amount, a limited stay can be granted. Unless you deposit, I can pass a limited order of stay, but I have to grant you liberty to take out a formal application. Acha.
Lordship,
As-
lordship, is there any application prepared for stay, lordship?
No.
That is what I'm saying.
So that is why temporary for a limited period with the liberty to take out a formal application.
But no execution has been filed, lordship.
Anyway,
No, but actually, since there is.
okay, anyway, as the appellant insurance company has deposited, দেখি রেকর্ডটা দেখি
No execution has been prepared, lordship.
no, you see, if there is no stay, execution can be preferred at
Lordship,
any point of time.
lordship. But we are not,
The
preparing
trial
it.
court, the trial court, it may be preferred
Because
tomorrow-
actually-
tomorrow itself.
no, lordship, actually, they have not satisfied the award, lordship, till date, lordship.
Anyway, if it is matured, it can be executed tomorrow itself. Anyway, as the appellant insurance company has deposited the statutory amount of rupees 25,000, the judgment and award dated 25/6/2025 passed by learned additional district judge, first court Jalpaiguri in MSC case number 331 of 2017 shall remain stayed for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within the as directed by the learned trial court, excluding the statutory amount within the period of 5 weeks. Stop. Liberty is granted to the appellant insurance company to file an application for stay upon deposit of the entire awarded sum. So you make an application for stay upon deposit of the awarded sum. Till that date, I'm staying it for 5 weeks. Because unless the stay is there, it cannot be made absolute till disposal.
Lordship.
Yes, the liberty to mention before the next circuit.
Lordship, actually, is there a direction to call for the LCR?
The trial court
Yeah, the
records
trial
be
court
called
record.
for
And
at
paper
the
book,
special messenger cost to be deposited by the appellant.
Lordship. And paper book direction, Lordship.
The paper books be prepared within 4 weeks from the date of arrival of the trial court records.
Grateful, Lordship. Yes, Lordship. I honor with the appellant, Lordship. Lordship, within time, Lordship. No delay, Lordship.
Yes, so have you served?
No, Lordship, this is the first time, Lordship.
Yes. Item 45. Who appears for this United Indian Insurance Company?
So,
Anyway, service is not complete.
no.
Yes, record and order, learned advocate for the appellant is present. Let notice be served upon the respondents and affidavit of service be filed. Liberty to mention before the
Lordship,
next.
this is the first appeal, Lordship, I automatically admitted, Lordship, that's why,
Yes.
there is a no delay, Lordship, that's why I,
The appeal is, learned advocate for the appellant is present. As there is no delay in preferring this appeal, the appeal is admitted. Stop. Let notice be issued upon the opposite parties and affidavit of service be filed. Liberty to mention before the next circuit.
and Lordship, paper book also.
Let the trial court's records come. Acha, the trial court's records be directed. Let the trial court's records be directed in upon payment of special messenger cost by the appellant. Hereafter, you mention obtain leave to file paper books.
Yes, Lordship, I honor with the appellant, Lordship. Same,
46. So
Yes.
same, make it same order.
same order, Lordship.
Seven,
Not today,
48,
not today,
49,
not today,
50,
not today.
51,
Same, not today,
52,
not today,
53,
not today.
55.
Appellant, Lordship, in this matter, actually,
Insurance.
service has already been effected, Lordship.
What is this can one?
Can one, Lordship. There is a delay, Lordship. So. this-
So have you served the copy of
Yes,
section 5?
Lordship.
Yes.
Nobody's has turned up. Despite of the service. Lordship.
Can one,
Lordship.
how many days delay?
So as per my calculation, Lordship, 182 days, Lordship. Maybe less for the stamp report.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Let the affidavit of service be filed. Affidavit of service filed be kept with the record.
Thank you.
The application for condonation of delay is taken up for consideration. Heard learned advocates peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient cause is shown for condoning the delay. Thus, delay in filing this application is condoned. Can 1 of 2024 is disposed, the appeal is admitted. Let notice be issued upon the respondents. The trial court records be called for upon payment of special messenger caused by the appellant. Liberty to mention before the next circuit.
Paperwork, Lordship.
Let the trial court records come. Thereafter, you take leave for filing paper books.
Lordship.
Yes, 56. Well, not today. Now, 54 तो 22 तारीख है or 64. Yes, 64. 64 not today.
My lord, I am for the respondent, my lord. Respondent number 2, my lord. Item number 64.
Yes, respondent, okay. Anyway, appellant is not, I'm making it not today.
My lord, yesterday also they didn't appear, my lord.
Anyway, let us see tomorrow.
My lord.
Service has already been completed, Lordship. There is a delay, Lordship.
Yes, record an order. You have served.
Lordship.
Learned advocate for the appellant is present. None appears for the respondent in spite of service. Let the affidavit of service filed be kept with the record. The application for condonation of delay being Can 1 of 2025 is taken up for consideration. Heard learned advocates peruse the petition filed. On hearing the learned advocates and upon perusing the petition, this court is of the view that the appellant has shown sufficient cause for condoning the delay. Stop. Thus, delay preferring the appeal be condoned. The appellant, thus the delay in preferring this appeal is condoned and Can 1 of 2025 is disposed. The appeal is admitted. Let notice be issued upon the respondents. And the trial court records are called for at the special messenger cost to be paid by the appellant. Liberty to mention before the next circuit.
Grateful lordship.
Seventy-two, okay, not today. Yes, not today,
74,
not today,
5,
not today,
37,
yes, not today,
29, 79.
seventy-nine, you are for the respondent. Whose applications? There are several applications.
Yes, my lord. Most of the applications are for the substitution as because the original defendant in this suit, he has died, he has expired, and before instituting the appeal, he has died, and we have made applications for substitution of the original defendant.
There are,
legal
first
heirs.
of all, this section 5 application is pending.
Yes, my lord.
Oh,
Section
prior
5
to that, the substitution application is to be taken up.
Substitution is taken.
Which are the application for substitution?
The applications for.
There are 11 applications.
Yes, my lord. As because during the pendency of this appeal, 3 appellants had also expired. So we have made application for substitution, abatement, and section 5 is also there.
Okay, just a minute. So this appeal was preferred within the time.
No, my lord, it was preferred after.
78 days. More than
It is-
3.5 years.
So let me see the substitution application first. Okay, without the parties being substituted, the entire thing will be defective. So after the parties are being substituted, the amendment is to be carried out. Thereafter, section 5 will be on contest.
So that we will not receive all the grant of only 3.
So you are representing which respondent?
We are for the response. All
All respondents.
In that
But
case,
some
I
of
can
the
serve the-
respondents have passed away.
applicants are-
Oh, respondents have not passed away.
The original defendant in the suit,
Yes.
he passed away, and after that we have made an application for substitution by the legal heirs of that,
Now the
the
question
original
is,
defendant.
original defendant passed away, but in the record, the
In
name.
the record, the name of the original defendant was there, as because before instituting after passing of the order in the first appeal, he passed away, and before instituting of the second appeal, we got the information and we have.
Okay, let me see that.
Can 3 হচ্ছে substitution.
So original defendant passed away.
Original defendant passed away.
So is he reflected in the appeal, memo of appeal, his name is there.
In the memo of appeal,
His name has to be there. এই ইয়েটা দিন, মেমোটা দিন।
The name of Bhavan is not there in the memo of appeal. But even number 9, Srimati Devi Shetty, she also died in 2014.
Who are the original defendants?
So, original name Bhavani Shetty, his name is not mentioned in the memo of appeal.
Bhavani Chetri was the original defendant. Yes, so far, this appeal is preferred, it is preferred against,
The legal hand.
yes, yes.
So this is the copy of the original. This is the original.
So, question is, he is seeking leave to proceed against the legal heirs. You have given the certificate of this death of this person. You are representing the legal heirs. You are the caveators also, or so upon notice being served, you are now representing.
And I submitted, event number 9, present,
Respondent number 9, Baby Chetri.
He also died here 2015. But her name is mentioned in.
But you are
It was
not
not in our
representing
knowledge.
her.
He died.
It was not in our knowledge that she had it.
So today I can take, today I can take up this application to grant leave to prefer appeal against this legal heirs. And the other is with regard to the substitution applications. Yes, let me see the substitution applications. আর can যেগুলো আছে,
Can 3.
can 3 দেওয়া আছে এখানে। can 3 তো একটা আছে। আরগুলো can আছে, অনেক কটা can আছে।
Total 11 cans are there. Can 5. Can 6. And can 9. So,
Can 3 is for substituting to, this is just a leave to proceed against this legal heirs of the original defendant. Yes. That is can 5 is for substitution of appellant number 10.
Can 5 is the substitution for appellant number 10. Appellant number
Have you
10
some
has-
copy?
Lordship, I have some copy, I have the.
Appellant number 10 is so far.
If they have not received it, I can again serve them by hand and we
Just
can
a
come back
minute.
day after tomorrow.
Can 6 is for?
Can 6 is for the substitution of the appellant number 9.
Appellant number 9. Okay. After how many days have you filed these two applications? From the date of death? Okay, can 6 is also another appellant. And can 9?
Can 9 is also for another appellant number 3.
Appellant number 3.
Yes.
So these are the applications for amendment, this thing, substitution. Then there are, with regard to 7, 8,
With regard to
can 7
Can-
and
can 7, 8 are the abatement and the section 5 that I have filed. As because the appellant, after the
Can 1 is.
can that is for the
with regard to second appeal.
regards.
But with
second-
regard to
that is-
substitution,
Those are in regard to.
substitution and setting aside amendment, there is another. First of all, this can 3, That is to permit him to proceed against the
Against
illegal aliens,
illegal
okay?
aliens.
The other are two substitution applications. You serve them, serve Mr. Ganguly, it will be taken up on Friday.
Yes, my lord.
Yes, learned advocates for the parties are present. Let copy of the application for substitution be served upon Mr. Ganguly, learned advocate for the respondents. Let this matter appear on 19/12/2025. Not today,
81,
not today.
82,
Yes, not today.
83,
83.
My lord, I am filing they had filed the opposite, affidavit in opposition. The reply I am
Whose
filing.
application is this? Can one?
Application is my application,
Application for?
for recall of the order.
Let me
And,
see.
they had filed the opposite, affidavit in opposition. I am filing the reply, copy, sir.
Yes. Whose application, this CO,
Hmm.
this CO 133 was disposed.
Was disposed of.
So in the original CO, who was the petitioner?
Is the petition.
Yes. What was the order passed?
Revision is allowed.
It was passed on contest or expertly?
Not on contest.
Yes,
Actually, we at,
let me see this order.
yes, adjournment was sought for. That was not granted. And junior was there and on this.
Just
hearing
a
of the-
minute.
On hearing of the petitioner, that has been disposed of.
Yes, what is your
Yes.
grounds?
Grounds are there, because all the judgment has been passed on that something has been escaped from the notice of the honorable court. And, but there is some difficulty is here, because the review or recall is to be heard by the judge concerned, same judge. But in this case, assignment has not been, because learned judge has been retired, superannuated. But it is proceeding without assignment of Chief Justice has not assigned it further. So there is a technical difficulty to proceed it further. In the last occasion, amendment, leave to amend the cost title, because petitioner was died and leave to amend was granted, but due to that has not been done.
Now, what
Because-
was allowed in your application? What was allowed in this particular application?
In that particular application,
What was the ground of challenge in that application? In the revisional application?
in the revisional application, they had challenged that the restoration and the substitution has been done without giving notice to the defendants. That was their ground. Without giving notice to the defendant. And actually, the fact remains that it is not, they all gone into the mistakes of the learned trial court, because defendant number 1 is present all along. He is the father of the defendant legal heir of the defendant number 2. And defendant number, the 2 who died, the suit cannot await when the legal heir is already in the record. One of the legal heir is record. So from the very beginning, on the mistake of the oversight and due to the submission, wrong submission or different
Yes,
submission,
that is
it has gone. And that
The ground of challenge was the. See, where is the scope of recalling? Court has passed an order
And-
upon considering the grounds, considering the materials on record.
but all that has not
Uh,
been truly reflected. That I will show
Whatever
in
is
the review.
there, you see, there is, no, what is the present stage of the suit?
No, suit has been dismissed. They had that was restored and they came before the learned trial, Honorable High Court. And by this order, no specific direction was given to for the of the lower court to how to proceed or all these things. All these things remain
That means.
unanswered in this
That means
revision
suit
petition.
was dismissed and thereafter it was restored by the trial court.
Trial court.
Against that, they came in revision.
And against that, they came in revision before this honorable court. On the ground that no notice was served. of them. But revisional court did not answer after rejecting also, and also on the considering the materials in the record, what they had, revisional court has done, but true picture is not different. That I have from the entire certified copy has been filed before your lordship by in my reply, affidavit of reply. It will be reflected from that. Entire certified copy is there from the lower court record, all the stages of the suit, of the miscase and everything. Entirely in wrong
What was
condition.
the ground of, let me see the order.
Yes,
Order on which this revisional application was filed.
yes.
Yes. So you have challenged this order 21/7/2022.
Yes, they had challenged.
No, 21/7/2022.
22 main order.
This is the order under challenge.
Is the order challenge. The miscase was restored. Allowed.
So by 21/7/2022, the miscase was restored.
Restored. And that was,
Just-
kindly.
Just a minute,
Let
you
me submit.
see, miscase,
Was
the-
restored.
this application was filed for restoration of miscase 71,
71 of
2015.
15. And kindly come to my page number, my reply, page number 55.
Let me see the order.
Now, order of dismissal kindly come. It will be clear then.
You see, the question is the reason order is passed. The scope of this court is very limited.
No, that I will show. But resent
Very-
order, but
Unless a fraud is played upon the court.
yes, that I will show.
That is the only,
Yes, that I will show.
this court has
There-
no scope
Where
to go into that order.
according that by orders, the where the suppression has been done and what has been done, that I will show. A full length hearing is required. It may be if your lordship will proceed, I have no option. But if assignment is required, then there is a technical difficulty. That I told as per technical difficulty.
Yes.
And if full length hearing is, it may be fixed in a 2 o'clock tomorrow or day after tomorrow, a full length.
Yes, what do you say?
I think that there is the question of technicality, but when they are looking the petition for substitution of a person, they are not.
See, I
taking
cannot
that.
go into the merits of the trial court order. The matter is decided. Only thing is this, if they can show their fraud was played upon the court, then only the question of recalling.
The opposite party has expired. And thereafter, a substitution petition was moved by my current. And in that, in moving that petition, they never raised the question of any technicality.
No,
So I do not feel.
technicalities can, it is can be raised. It is point of law can be raised at any time.
It's the petition for recall. When an order has been passed on merit, practically there is no scope unless fraud has been practiced or materially it affects the jurisdiction or any notice has not been served. In such cases, court may interfere, but in other cases, there is no scope.
My lord, I am submitting one judgment on this point, recall.
I I like to submit before your lordship a Supreme Court decision.
Okay, let me see your grounds for recalling.
Yes, my lord. My lord, a full length hearing, it may kept tomorrow on 2 o'clock.
So let it be placed before the next circuit.
Lordship, enough time has been taken. And the record will reveal from Can, one and other petition.
No time we have taken. It is just, yes, submitting like this.
No, no.
Yes, I am fair. Where in the recalling application, I have taken time. You have taken time for your illness. Record will speak, you have taken time for your illness. In the recalling application, I have not taken. And that also in the main application, we did not appear before which, on the previous dates. That has not been served.
So this is your.
No affidavit in.
On what grounds this order will be recalled?
My lord, I will show it tomorrow. The details of the suppression of fact that has been taken while submitting the before your lord.
What was there in, it was in the matter of record, nothing.
No, not of record. That I will show that.
Whatever was there in the petition and your affidavit in opposition, on the basis of that, the decision is arrived.
No, I have not. We have not filed the affidavit of opposition. We did not actually appear. On that date, we have appeared and sought time. That has been rejected and order has been passed. The record will show. Everything I will show. No, record. Kindly go through the previous record. We have not taken a single time. They had taken time, and on that date, last date, we none appeared and lordship given a time to appear for the parties. And on that parties, we have appeared, sought adjournment, but it was rejected.
And 11/8/2025 order may kindly.
That is 2 dates. 2 dates, that is 28/7 that they are telling. On that date, none appeared. We did not appear. And lordship,
Okay, come tomorrow with a list of dates.
Yes. Right.
Record on order. Thereafter, I shall ascertain whether some assignment is required, then it will be sent for assignment.
Yes.
Learned advocates, so the parties are present. Are learned advocates. The affidavits of affidavit in opposition and affidavit in reply file be kept with the record. Learned advocates are requested to come with a list of dates on 19/12/2025.
My lord, one indulgence.
Yes.
On the last occasion, a liberty was given to correct in the cost title. It
Yes.
may be correct. If we correct,
Liberty is granted to correct the cost title if not corrected. I'm giving it day after tomorrow. তাহলে ইয়ে করে দিন
Monday,
20 to
Tuesday
20
করে
to
দিন।
12. 20 to 12, yes.
March.
Yes, call the next.
I'm appealing for the petition number.
Is the restoration application?
Restoration.
On a previous also, they have basically taken explicit for.
Let me see. Yes.
Lordship, on 27th of November.
No, wait, let me see. What
2025.
is the can?
Yes, Lordship.
Can one,
Can two,
can two,
can two 2025.
can two. So when was the order passed?
27th of November.
27th of November.
November.
Yes, what do you say? Yes, dilatory tactics. Yes, where it is filed within time. There is no delay in filing this application.
It was the.
Very well, very well. Due to some, the lawyer could not appear, the matter was dismissed. Now that after the dismissal, they have come, they have preferred this application in time. Yes.
There is an order for maintenance and we have filed the execution case and what it was taken. That was the urgency which was needed by the petitioner. And by way of the order, it was passed that they have to make an interim payment of.
Yes, yes. So let it be heard out. Thereafter, you
Yes,
can
I am-
agitate
I
all
am
these
paying-
points. Yes,
The order that has been passed is not being carried out with.
very well. So
No, no,
these
Lordship, I have
let this
annexed-
matter be restored. You take all
I have
these points.
annexed, all the payment receipt, Lordship,
Yes.
kindly see page 11 onwards.
Learned advocates
I
for
will-
the parties are present.
Lordship,
This is
I-
an application for recalling the order dated 27/11/2025 passed by a learned coordinate bench of this court dismissing CO 96 of 2024. Upon hearing the learned advocates and upon considering the petition, it appears that the learned advocate for the petitioner could not appear on 27/11/2025 due to illness. Thus, the petitioner has shown sufficient cause for the absence on the date fixed. Thus, this application for restoration, thus the order dated 27/11/2025 stands recalled, and this petition CO 96 of 2024 is restored to its file. Liberty to
Only one
mention,
thing, Lordship, on this order dated 20th of August 2025, that was an interim order.
yes.
Let that order be restored, Lordship.
No, entire, I am saying, restoring the entire revisional application.
So that the petitioner can continue.
No, entire is, application is restored.
Deeply.
The order is not being carried out. That they are.
I have annexed all the.
So
all the-
get, so file an application for dismissal of this case.
Satisfy the court. As per it was ordered that they will pay me the maintenance and the amount of interim amount of.
So take this plea at the time of hearing of this application.
Deeply. Lordship, the matter will come up in the next.
Yes, liberty to mention it.
I've got the appeal.
Yes, what is the ground of challenge?
The ground is the the tribunal allowed some lump sum,
Let me see the order. an injury case.
It is injury case. Interest in lump sum.
Interest
Lump
is
sum
how
amount
much?
has been
Oh, from the
award
date
value
of this order till realization.
till years.
So you are only agreed by this portion.
Now, I am agreed that the amount is 2,40,000.
Yes.
My medical expense, it is proved that my medical expense 2,70,000. And it is proved that. 2,70,000.
So medical expenditure have been proved to the tune of 75,000.
But, no,
Okay.
but,
And the petitioner had to prove.
the learned tribunal felt to consider that lordship, and see page number 17.
1 lakh under the pain and suit. Mhm. Let me see the order. So now the question is, as per the order of the learned trial judge, you see, medical and loss of earnings and damages for pain. How long you were in hospital?
The treatment is going on, but at that time,
No, how long? How long you were admitted to hospital? It is not a question of disablement.
disablement has malad, 50% disablement.
Where? Where is that?
Page 40.
Temporary disablement. Yes.
4 fingers removed.
Medical expenditure is 75,000. Proved 70,000. And what's cost of treatment? 1 lakh. Under the head of pain and sufferings. Regarding 50% disablement, pain and sufferings, pain and suffering.
Pain suffering.
70,000 medical expenditure, 50,000 for delay.
Lump sum interest, whether it is contradictory to section 171, my lord.
So otherwise it is 1,90,000.
Otherwise, 1,90,000.
Yes. Yes.
What three defects are there? Number one, the date of accident was on 23rd August 2008.
Okay, date of accident, date of accident?
The date of accident,
23rd August.
3rd August 2008. And the disablement certificate was issued on 23rd March 2014, after lapse of 6 years.
Yes.
Settlement certificate, the point is there, review of the 5 years, what is the condition of now condition is not, whether it is reviewed, whether it increased or decreased.
So the learned trial court did not proceed on the computing compensation on the percentage of disablement. Simply
That's
stated,
simple.
so disablement certificate was issued after 6 years, but 4 fingers is removed. That is undisputed. 4 fingers of the leg, toe.
Page 67,
Is 67.
last line.
Yes. Yes, X-ray of right foot.
4, second and third letter.
Crush injury.
And
And this is the
67.
medical report. So
Discharge-
date of admission,
And there is date of admission.
26th August, 8. Date of just 7th of September 2008.
and discharge. So he was there for about 11 days.
11. And last time, now the patient is stable and being injured in critical condition.
Again, the review for next dressing malad. This is
Not by single doctor or a.
No, you see, beyond a particular percentage, medical board is necessary. So it was exhibited.
exhibit,
No.
but without any objection malad from the.
No, no.
part-
If it is above 50%, definitely medical board. So it is exhibited
It is exhibited without any.
and
objection.
issued by, yes, government hospital.
Government hospital.
So your contention is this medical certificate was issued after 6 years. And regarding,
Regarding the, second point is that everything is covered. And the Supreme Court always, I just referring to was only judgment.
yes,
Lump sum judgment, lump sum amount 5 lakhs, 4 lakhs in case of fine. And just. This is all the reasons. Total compensation. Now
so
the word used.
this is death. This is the death
Death.
case.
And
Yes, let us see the injury case. This is also death. Yes, record an order. Anything to cite?
What things that but the there is a settlement was 70%, but the tribunal 20%. Next page.
So what was the monthly income? What was the age of this person?
11 years.
Yes, record an order.
My lord, I have no calculation, my lord, regarding this.
Yes, learned advocate for the appellant and learned advocate for the respondent number 1. Orient, New India Assurance Company Limited are present. Are learned advocates for the parties. The appellant before this court was a claimant in a motor accident claim case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 8th December 2017 passed by the learned additional district judge, second fast track court, Jalpaiguri in MSC case number 442 of 2008. Stop. The grounds, next para, the grounds on which the judgment and award is assailed is the learned trial judge has granted inadequate compensation and has failed to take into consideration the partial disablement suffered by the victim. Heard learned advocate for the appellant and learned advocate for respondent number 1, insurance company. Learned advocate for the appellant submits that the learned trial judge just considered the compensation on account of pain and sufferings and the medical expenses and have awarded a consolidated sum of rupees 50,000 on account of delay. However, in the instant case, if monthly income on notional basis, future prospect, disability of 50% is taken into consideration, the total claim should be 7,56,000. Learned advocates for the opposite party, respondent number 1, insurance company submits that the award, the compensation awarded is just and reasonable, and the disability certificate which is relied upon by the claimant appellant was issued after a period of 6 years. Stop. I have given consideration to the learned advocate for the appellant insurance company relies upon the following judicial decisions. Relies upon the following judicial decisions. Pasanna versus SHERANA, BASAPPA and another, reported in 2025 within bracket 4, TSC 63 within bracket SC, Kamukakshi and others versus Union of India, reported in 2023 ACJ 1659. Next, Mukhtar versus Deputy Manager Sriram General Insurance Company Limited and another, reported in 2025 within bracket 3, TAC 23 SC. and Me Too versus New India Assurance Company Limited and another reported in 2025 within bracket 2 TSC 505 Calcutta. I have given consideration to the materials on record, the decisions relied upon, and the judgment and award passed by the learned trial court. Upon perusing the materials on record and considering the facts of the case, it is an admitted position that the victim has suffered 50% of disability. It further appears that the victim was admitted to hospital for about 11 days. Stop. Upon considering the age of the victim, which is 11 years, the period of stay in the hospital, which is about 11 days, and the fact that the victim has suffered temporary disability of 50% and 4 of his fingers were, yes, where is that? 4 fingers were amputated?
60, page 67.
Page
67.
67, yes. No, which paragraph? 67? That is X-ray.
It's called 4 lateral, 4 lateral 1/3 of renal skin separated off.
Okay, that is,
This language.
no, which way that is? Page 67.
Yeah. Line skin. Paragraph.
Okay. Where it is,
Portion management.
where it is observed, the injury report were 4 lateral toes with lateral 1/3 of ventral skin separated off, removed and cleaned. Rest under general anesthesia on 29/8/2008. Stop. Upon considering the nature of injury and the disablement certificate, the period of stay in hospital and the age of the victim, this court is of the view that the amount on account of disablement, pain and sufferings should be enhanced to rupees 3 lakh. With regard to the medical expenses, this court does not find any necessity to interfere, and the medical expenses as awarded by the learned trial court shall remain as rupees 70,000. Hence, this court is of the view, although by calculation it comes to rupees 3,70,000, but however, as the courts are empowered to grant just and reasonable compensation, this court is of the view that rupees 4 lakh should be a just and reasonable compensation to be awarded to the claimant's victim. Thus, this appeal stands disposed. Judge, yes?
Out of the 40,000 already given.
Yes, is that actually recorded? What? I'm just recording the entitlement. Thus, this appeal, FMATA, thus this appeal stands disposed. The judgment and award dated 8th December 2017, passed by learned Additional District Judge, 2nd Fast Track Court, Jalpaiguri, in MAC case number 442 of 2008, stands modified to the extent that the claimant appellant is entitled to rupees 4 lakh from the respondent number 1, New India Assurance Company Limited. Stop. The as it is submitted by the learned advocates that rupees 2,40,000
2 lakh, but
is already paid to the claimants, the 2,40,000, but without any interest.
without any interest, Lordship.
The respondent number 1, New India Assurance Company Limited, shall pay rupees 2,60,000 along with interest at the rate of 6% per annum from the date of filing till date of deposit of the earlier sum. With regard to 2,40,000, which is, no, 2,40,000. Oh, it cannot be 2 lakh.
2,60,000, they have to put it 1,60,000.
No. Question is, I have awarded, that is 2 lakh. No, probably that is 3 lakh and that's 70,000. And they have 4 lakh. So you are required to deposit rupees 4 lakh.
1,60,000. Because we have already paid 2 lakhs.
Okay. So rupees 1 lakh, rupees, okay, 1,60,000. 1,60,000 along with interest at the rate of 6%. 1,60,000 interest at the rate of 6% per annum from the date of filing till today. But with regard to that, that lump sum interest is given. Yes, but with regard to that, a lump sum interest is given. Anyway, I'm just 1,60,000 from the date of filing of the claim case till to date. Such payments shall be made within 5 weeks from the date of communication of this order.
50,000 including.
Yes. That is why I'm not awarding any separate interest on that, because that was taken care of. So only 1,60,000, you pay 6% interest from the date of filing of the claim petition till to date. Yes. OPM fix अच्छा देखे दी OPM fix matter.
I'm for the appellant, Lordship.
OPM fix matter. Where is the other side?
Last. And Lordship, affidavit of
So you are appearing for the respondent number 1. Yes. What is the ground of challenge?
Yes, Lordship. Lordship, first ground is the income, Lordship. Lordship, this is the deceased. He is a driver, bus driver, Lordship, and his monthly salary is the 15,000, Lordship, and it is exhibited.
Where?
Exhibit
Page.
salary certificate exhibit 16, Lordship, page number.
Where is the award passed by the trial court?
Lordship, award Page number 27, Lordship.
Page 27. Yes.
Only 10,000 has been awarded, Lordship.
How much?
10,000 in income, Lordship.
10,000 income is taken as
Taken
notional
as a
income.
calculation, Lordship. And the,
Now, question is, did you examine the employer of the
yes, Lordship.
victim?
Yes, Lordship. That is exhibit number 16, Lordship.
Exhibit number?
16. Page, page number, Lordship, 81, Lordship. This is the salary certificate, Lordship, and it is exhibit 16. Without objection, Lordship, it was exhibit, Lordship.
No. Question is, did the employer come to depose?
Yes, Lordship.
81. Okay, this is exhibited.
Yes, Lordship.
Yes.
Page number 26, Lordship.
Page number 26.
Yes, Lordship. Name is Ranjan Polas Datta, Lordship. Witness number 3, Lordship.
Yes. Yes.
Lordship, he is the brother of the owner, Lordship, said Bas, Lordship. And he deposed the on behalf of his brother, Lordship, Minal Kanti Roy.
Yes.
Got it, Lordship?
Oh, he was a driver of what vehicle? Bus?
Bas, Lordship. PSV, Lordship, PSV Bas, Lordship, heavy vehicle, Lordship.
Yes.
Lordship, in this regard, I have relied upon one judgment, Lordship, Supreme Court judgment, Lordship,
Yes.
Janovi and others versus ICC Lumber Insurance Company Limited, Lordship. Lordship, here in absence of proof of salary certificate, Lordship, the income of the deceased, Lordship, rightly taken care of that, Lordship. In the number.
So future prospect taken into consideration.
Lordship.
So 7 accept that notional income of 15,000.
And Lordship, parental consortium, Lordship, are within.
Consortium, how much? To the wife?
No, Lordship, parental consortium, Lordship, to the children, Lordship.
Actually, that you see, it's not. So 40,000 was awarded to the wife.
Lordship.
Regarding that parental consortium, there are some disputes, okay? Filial consortium, yes, it is okay.
Lordship.
40,000 is already awarded to wife.
Yes, Lordship.
Parental consortium not awarded.
Not awarded, Lordship.
Yes, that's all.
No. Lordship, parent consortium, in this regard, Lordship, I have relied upon one judgment, Lordship, Supreme Court of India, Lordship, to recent judgment, Lordship, 2025 judgment lordship. Here lordship, parental consortium is given 44,000 per each, per each claimants lordship. There is a four
So you
claimant.
see, as part of this, the division bench judgment, that in some cases, yes,
Yes, lordship.
filial consortium can be given.
Lordship.
Dekhi judgment time.
2025 one TSC, 2025 one TSC 80.
No, you see, Pranay Shetty was considered while passing this judgment. Because you see, that is that parent judgment, Pranay Shetty.
Yes, lordship.
Usually that is taken into consideration because Pranay Shetty has rejected that parental consortium.
Lordship.
So Pranay Shetty was not considered here. So at best you see, even if it is accepted that parental consortium should be given, total consortium should not exceed 80,000. At best, if the court thinks
Lordship.
parental consortium should be given, at best total, whoever be the representative, at best 40,000.
Lordship.
Although you see, Pranay Shetty has overruled, has rejected the plea regarding parental consortium.
Lordship.
In some decisions, yes, filial consortium, yes, some cases it is approved. So
Lordship, is
your
the-
ground of challenge is
Here
consortium.
also lordship, Pranay Shetty also consider lordship. Kindly see judgment lordship.
So the
809
Pranay Shetty regarding that parental care and consortium, that Rakesh's case was,
lordship.
that was not accepted
Not accepted.
in Pranay Shetty. So whether the Honorable Supreme Court, while passing this judgment, considered this Pranay Shetty?
Yes, lordship. Page number
Where is
8.
that observation, Pranay Shetty?
Not observation lordship, but the calculation is there lordship only.
No, regarding consortium aspect.
Yes.
Others are okay.
Yes.
Consortium aspect, whether Pranay Shetty was taken into consideration.
Lordship, loss of parental consortium lordship. 44,000 lordship.
No, you see,
As per the
go as
public
per
and
laid
import-
down in Pranay
Pranay
Shetty.
Shetty lordship. Super.
But Pranay Shetty did not lay down, you see, this parental consortium. Yes. W3 deposition, yes, that is page 26, yes. That his brother has transport business. Yes, that certificate is admitted. That was issued by him.
Yes, lordship.
Parental consortium is concerned. No, Pranay Shetty did not accept that parental consortium aspect. And in some cases that Nuna Chand and some filial, of course, some of the filial consortium was not before the Honorable Supreme Court with regard to Pranay Shetty. That came up subsequently. Only that parental consortium, parental care came, and the Honorable Court that in Pranay Shetty's case did not accept that parental consortium.
Even if Lordship, our High Court also passed some judgment to.
However, you see, in filial consortium, yes, upon considering that Luna Chand matter, which has considered Pranay Shetty, and thereafter has come to the conclusion with regard to filial consortium. Yes. Filial consortium, yes, to some extent. And even if the court awards filial, that's parental consortium also, at best, it should not be more than 40,000. At best. Not 40,000 each. Okay.
And Lordship, we also pay for interest.
Interest was awarded.
Whatever. It is 6%, Lordship.
So 6% is reasonable. Yes, record an order. 6% was awarded. Oh, right. From the date of the claim, it is not
Yes.
awarded. Yes, learned advocate for the appellant and learned advocate for
Lordship, may I hand over to the.
respondent number 1 is present. Third learned advocates. Hearing is concluded. Fix 19/12/2025 for judgment. আচ্ছা এইটা পাঠিয়ে দেবেন চেম্বারে, ঠিক আছে? এটা পাঠিয়ে দিচ্ছেন, এটা তাড়াতাড়ি সই করে আগে পাঠিয়ে দেবেন। আর সেকেন্ড হলো এই আরেকটা আছে আপনার, যেটা ফর অর্ডার হলো, ওই একটা ওই সেকেন্ড অ্যাপিলে ফর অর্ডার, দুটো চেম্বারে আবার পাঠিয়ে দেবেন। ওটা তো যাবে পাঠিয়ে।
Lordship, may I Lordship? Lordship, in Pune City, Lordship, every year, every 3 years, Lordship, 10% enhancement has been given, Lordship.
Yes, give that. So your grievance is only this parental consortium.
Income and.
Dekhi.
And interest. 10% enhancement. Great.
Both sides are present.
So, notice to the other side, I have served this affected. My affidavit of service is ready. But nobody is appearing on behalf of the wife lordship.
So
It's
okay,
a-
come tomorrow, I shall take it up. Yes, not today.
89.
59, the other side is not here. Yes? Anyway, it will be taken up tomorrow.
I'm for the appellant.
The insurance company advocate is here.
The copy has been served, affidavit service is ready.
It is ready for hearing matter.
My lord.
So his presence is necessary. Who appears, you see, you contact the advocate, I'll take it up tomorrow.
My lord. Very short issue. The judgment in the Pranay Shetty and Salaman has not been considered. Very short issue.
Anyway, see if he,
I'll-
if you can get him.
No, you can say, oh, appear for it. ठीक. Then खबर नहीं।
Okay, 91 to 94, probably it was adjourned yesterday. 91 to 94. You are appearing in which case? 90?
90.
Okay, 90 I am making it not today. And 91 to 94, it is already adjourned. Ninety-five, nobody say, okay, not today. Okay, let us see.
Lordship, I am for the bank, Lordship. The bank has preferred this review application. On the last two occasions.
No, other side is here.
The other side is not, there were twice directions upon them to give a opposition to my review application there. Now the difficulty is, Lordship, if your Lordship kindly takes the improved order.
No, in the absence of the other side. Anyway, not today. Or not this week, Monday. Intimate the other side, okay? I'm making it on Monday.
Then I'll take only one order that the borrower has gone for execution postings before the TRT. Only that, since the review petition is pending before the High Court, I'm taking for only one order that the execution postings be.
Okay, come on Monday, I shall see.
It should abide by the result of.
To
this.
intimate the other side, I'll see you on Monday. Yes, not today. Oh, it is due to appear or today? One Cantu is here in the list.
Your Lordship, I am for the respondent opposite party number 1 and 2 in this matter, 102. My junior friend is submitting. We will submit the affidavit in opposition against stay application, can 2.
101 is called.
Oh,
101.
I am 102, Your Lordship.
Okay, let it be taken tomorrow. Tomorrow I shall pass necessary directions. Hundred and two to 19 তারিখ আছে 103 call 103.
Lordship, kindly fix it on Monday. The landlord but
Monday?
Monday,
Not this week.
not today.
Not today.
The case is ready for hearing, Lordship. So I have already served the informal paper upon the insurance company, Lordship. So,
Are you ready to argue the matter?
Lordship,
Very well.
if your Lordship time permits.
Hello.
Yes. Yes, you are the appellant Clement.
Lordship,
Yes, what is the grounds of challenge?
Lordship, mainly three grounds are there, Lordship. So, number one, Lordship, so for the quantum, that is, so for the notional income of the deceased is concerned, Lordship, deceased was a private tutor, Lordship. And the income actually, which actually they paid for actually, It was 9,000. So it was mentioned in the column number 6 of the application, claim application. And 6,000 has been taken into consideration. Number 2, no interest has been awarded.
Okay.
So
9,000,
that
where- which case?
in view of the section
No,
170.
just a minute. Which page?
Lordship, page number 33, Lordship, of paper book.
The future prospect is taken into consideration.
Future prospect has been taken into
But
consideration.
so far the income is concerned, it is considered as 6,000.
6,000, Lordship.
Just 6,000.
কি দেখাচ্ছিস আমাদের? ওরে না।
Future prospect taken.
Future to 40% has been rightly added, Lordship. This is বয়স কত ছিল? বয়স কত ছিল? 20 years.
How much it comes? 9,77,000.
9,77,200 has been awarded, Lordship. Our claim,
Is an unmarried person.
yes, Lordship. Our claim was 13,90,800.
13,97,000.
And number 3, Lordship, for number third one is, Lordship, 10% of the general damages should be awarded in view of the judgment of the pronunciation, Lordship, in every 3 years. That has not been awarded, Lordship.
10%, how much it comes?
General
40,000.
damages
Yes?
should be enhanced in every 3 years.
No, how much general damages? Is,
70,000.
70,000.
70,000, Lordship.
So it should be 10% more.
Could be. কোথায়?
Filial consortium is 40,000 each or total only one.
Lordship,
Both parents are there.
both parents are there.
So it is only 40,000 is given.
40,000. কোথায় পড়ে গেল? বলো না, wait, বলবে তো। যে under the heading general damages, Lordship, 70,000 has been taken into consideration.
Just
Loss of estate, let me complete, please, because you'll get your chance. Please allow me to submit. Even to submit now, wait now. So under the heading, Lordship, general damages, loss of estate 15,000, funeral expenses 15,000, and loss of filial consortium 40,000. Total 70,000 has been added, Lordship. That has been rightly added, Lordship.
No, filial consortium should be 40,000 each for both the parents. Oh, here, how many parents have come?
No, parents, father and mother both are alive.
Yes.
So under the, as a parental consortium, 40,000 has
Filial consortium.
that is filial consortium.
Yes, it should be 40,000 each probably.
No, Lordship, 40,000. So for
That
the
is
judgment,
2020.
40,000, that will come under the heading of filial consortium, but that will not be divided, I guess.
No, 40,000 for both the parents each. That is 40 plus 40.
So
So let us see the judgment of pronunciation.
judgment.
Let us see that. So far wife is concerned, 40,000. If there are both parents, probably it is 40,000 each.
কোন করে না?
See,
No,
filial.
actually, Lordship, what happened?
No, let us see pronunciation.
Lordship.
No, pronunciation, there is no observation of filial consortium.
Lordship,
Yes.
absolutely, Lordship.
Let us see that, let us see that Nanu Chand.
Nanuram, Lordship.
Nanuram, yes.
Nanuram, Lordship.
Probably if
So
there,
in
how much is there regarding Nanuram?
in the case of Nanuram, Lordship, there is only the consortium has been
That is father and sister.
consortium has been elaborately discussed in the
Yes.
judgment of Nanuram. Spousal consortium, parental consortium, and filial consortium.
Yes, very well. Regarding that spousal, that is the filial consortium.
Consortium,
Filial consortium regarding Nanuram, How much is provided?
40, no specifically, even in the judgment of Nanuram, filial consortium comes under the heading of consortium. So only consortium has been mentioned in the judgment of Pranay Shetty. But in that case, in the case of Pranay Shetty.
No, in Nanuram, probably it was this father and the sister.
Why not? Even I don't know.
No, Nanuram it was
40,000. Consortium, only consortium has been, the term consortium has been hired from the judgment of Pranay Shetty. Now that consortium, sometimes it is, that prefix is being added to the consortium. Sometimes it is.
You see,
1,000
earlier, the concept was confined to wife only, okay?
Lordship.
But subsequent to this judgment
Lordship.
of this Nanuram, it is extended to this
Mhm.
parent and this.
Absolutely, Lordship.
Earlier,
Lordship is
the
absolutely correct.
concept was only with regard to wife.
Lordship, absolutely correct, Lordship. 40,000 each, Lordship. That
In-
will be added.
In Nanuram,
No. But the problem is that in the case of Pranay Shetty, Lordship, the father has not been considered.
you see, Pranay Shetty did not observe about filial consortium,
Absolutely, Lordship.
neither about parental consortium. It was confined to only spouse,
Absolutely.
which was the earlier concept.
Lordship.
Subsequent to Pranay Shetty,
Lordship.
Nanuram took into consideration filial consortium, which is accepted by some of the high courts and
Lordship.
by the Honorable Apex. Court.
Lordship.
But regarding parental consortium, now this Pranay Shetty expressly refused to accept that
Lordship.
parental consortium.
Lordship.
So 40,000 each
40,000 each.
in Nanuram.
Hmm.
Let me see the citation.
Now the problem, difficulty is that in the present case, Lordship, in the present case, tribunal has passed the award only in favor of the mother, Lordship. Father has not been considered. So for the
Father is not a party.
no, father has been made party, but he was not awarded anything. So in view of the judgment of the Pranay Shetty.
Actually, no award is given in favor of the father.
Lordship.
So entire award in favor of the mother, although father is a party.
Father has been made.
Anyway, father has not come. So whatever is challenge is thrown by the mother.
Lordship.
The father has not come up before this court.
Lordship.
So according to you, this general damages should come to how much?
It should be 84,000.
84,000.
77,000, Lordship.
So 30 and this is 40,
70.
77,000.
77,000. Number two, Lordship, no interest has been awarded.
They have deposited within 2 months.
Within 2 months, but so far the section 171 is concerned, from the date of filing, interest should be calculated. The award has been given on in the clause of default clause. In
And
default,
only if they fail.
Lordship, in default.
Yes, what do you say?
And next one, Lordship, I'm not finished, Lordship. Now, main point, my Lordship, regarding the notional income of the deceased, Lordship.
Yes, that you said that
Yes,
the
6,000,
tribunal has not accepted
6,000.
9,000.
9,000, 6,000 only, Lordship, has been awarded, Lordship. Since the deceased, this was a private tutor, and more interestingly, Lordship, the accident occurred in the year 2022. In the recent, going by the present state of economy, Lordship, and going by the increase price rise, Lordship. Going by the present state of being, Your Lordship, I would like to refer the latest judgment passed by the Honorable Justice presided over by Sanjay Karol, Lordship, and Prashant Kumar, Mr. Lordship.
What was the age of the victim?
Only 20, Lordship. Only 20, Lordship.
20.
Only 20, Lordship. Only 20, Lordship. So this is the, let me please allow me to complete. This judgment was passed, Lordship, in the year 2025, Lordship, comprising Honorable Judges Sanjay Karol and Prashant Kumar, Mr. Lordship, and judgment was passed on 8th August. Please allow me to speak. Judgment was passed on 8th August 2025. So what was the contention of this judgment? So judgment, the spirit of the judgment, Lordship, is that there are number of cases are being filed, number of appeals are being filed on the ground that notional income, that income has not been ascertained. So what should be the method of calculating the notional income? And that is the focus, that is the spirit of this judgment. So in this case, I am referring this judgment. Judgment. Point 9. Lordship, I start with paragraph number 9, Lordship.
Yes.
On the aspect of monthly income of the minor appellant, here we are starting with minor, Lordship. So I will come back to adults. On the aspect of monthly income of the minor appellants, we are inclined to interfere with the judgment and order of the courts below. In the present case, please. In the present case, it is evident that the courts below have failed to take into account the monthly income of the appellant while determining the quantum of compensation. It is now a well-entrenched and consistently reiterated principle of law that a minor child who suffers death or permanent disability in a motor vehicle accident cannot be placed in the same category as a non-earning individual for the purposes of assessing the amount of compensation because the child was not engaged in gainful employment at the time of the accident. In such a case, the computation of compensation under the head of loss of income ought to be made by adopting, at the very least, the minimum wages payable to a skilled workman as notified for the relevant period in the respective state where the cause of action arises. The said observation was rendered by this court in Kajol versus Jagdish Chand and others, and Baby Sakshi Kerola versus Manjur Ahmed Simon and another. I come to paragraph number 16 next, Lordship. All these paragraphs are very relevant, Lordship. 16. We may also observe that in general, that is accidents involving adults, we are often confronted with situations where the minimum wage data is not readily available. And every so often, the question that has been made up to this court hinges only on the calculation of income. In that view of the matter and in the hope of reducing the claimants' need to file appeals, which I was emphasizing, in the hope of reducing the claimants' need to file appeals to this court or even the High Court, we deem it appropriate to direct that in cases where the claimant has failed to furnish appropriate details of income or adequate proof thereof, it shall be the responsibility and obligation of the contesting party, more particularly the insurance company, to furnish before the tribunal the applicable minimum wage as duly issued by the concerned government. I just skip paragraph number 17. Paragraph number 18, insofar as the direction issued regarding the furnishing of the schedule of the minimum wages by the insurance company in cases where the income of the claimant / deceased has not been properly established, let a copy of this order be sent by the Register Judicial of this court to the learned Register Generals of the High Courts, who shall ensure that a copy of this order is sent to all motor accident claims tribunal to see that the direction is followed strictly. So this is the latest judgment which has been passed on 8th August 2025.
Very well. You have completed?
Lordship.
Yes.
So, Lordship, one more, just I would like to add one thing, Lordship. So far, I am giving emphasizes on the minimum wages, Lordship. So the period.
There is no minimum wages for private tuition.
Lordship, that is my submission, Lordship.
Yes.
The minimum wage for a private tuition teacher in West Bengal in 2022, the
Let me
accident.
see that.
May I read out, Lordship?
No, no, give that. I can
Lordship.
see that. You give a copy to your learned friend?
Lordship, I will give it. I'll read this. Allow me to read. Allow me to.
Okay, skilled 9,685.
Yes. Zone A, Zone B, Lordship, that has been defined. We find the corroboration from the cross-examination,
Where
Lordship.
is the next page? Continuing page?
This is the only page, Lordship.
No, note on applicability.
Oh, Lordship, I can give it, Lordship. It is the only page. No, the relevant portion actually which have taken the printout.
So come tomorrow then?
They can furnish tomorrow, Lordship.
Yes, record an order. Yes, let me hear him. You
Lordship.
furnish only this one tomorrow, yes.
So, point of confusion has got to be taken. And second, only DC kindly carries the page 40.
Page?
Page 14, cross-examination, Lordship.
In cross-examination,
Yes.
Monirul passed Madhyamik examination and used to stay at Kamarpara and keep private tuition. I do not know the name of the student whom you talk.
This is a version of the mother.
This is the
Version of the
okay,
mother.
ma- mother.
Mother. How could mother know about the name?
What is this? Actual educational qualification of the he is a boy of 20 years and studying
Student,
student.
Student come private. It has been mentioned specifically in the claim application that he was a student
9,000 per month.
month. We have prayed for 9,000.
Madhyamik student. Only
But-
look past Madhyamik. In this regard, no certificate was reported.
No. Certificate cannot be from one person. There are several persons from whom used to give private tuition. Okay, this is not a school or institution.
Madhyamik examination passed on.
It is
Maybe.
cross.
Maybe he is to teach primary students or whatever it is. Now the question is, where is the continuation of this? You bring this tomorrow.
I will bring it tomorrow, Lordship. Certainly will bring it
Yes.
tomorrow, Lordship.
Record an order. Learned advocates for the parties are present, had learned advocates. Let it appear for final hearing on 18/12/2025
Lordship, kindly fix it at 2, Lordship.
at 4 PM.
4 PM, Lordship. Grateful, Lordship. Tomorrow one matter. Huh? Okay. Grateful, Lordship.